students. Today's topic is intellectual property law. This topic is very important in present world which is governed by e-commerce. For example, mobile in my hand, it is basically a bundle of copyright for us and as well as patent as well as trademark. How? The name of the company is protected by the trademark. The front screen, the software, the Android based software is protected by the copyright under this as software are protected by copyright. Moreover, when I open this handset, the design part is patented. This is an example how much intellectual property law control us. For example, I am wearing the earrings of a leading jewelry brand which is also trademark under the intellectual property law. Further, to move ahead, let us look at the subtopics that we will be covering today. The meaning of the intellectual property law, the significance of the intellectual property law, historical perspective, types of intellectual property, the trademark and its concept, types of trademark, the registration procedure of the trademark and the infringement, that means violation, and as well as the real life field through the case laws under this act. Now, let us discuss the meaning of intellectual property. The term indicate intellectual plus property. Property means entitlement of ownership to the possessor. It allows the owner to use, gift and sell it. If we talk about types of property, we have movable property, immovable property and a third special category known as intellectual property. Now, why it is called intellectual? The answer is when it is applied to actual world, it creates useful and valuable things. For example, current trial of COVID-19 vaccine. When it comes to be successful, it will be patented as intellectual property, will be definitely save us from the deadly pandemic. The pharmaceutical research company use the idea of vaccine development and create a property out of it in terms of money while selling it as a patent right to the user. There are so many historical perspectives about intellectual property, how it came into the inception. There are two ways to understand. First is ancient time. The earliest records relating to intellectual property dates back to 6th century BC from Sybaris in the ancient Greece. It supposedly granted a year-long exclusivity for bakers to make their culinary invention. In a manner of speaking, the rise of intellectual property originated from the rising of a bread. Interesting, isn't it? Now, the current perspective about intellectual property is during early 1800. The idea of global protection of intellectual property rights floated among legislative bodies, and it was in the year 1883 that in the Paris Convention brought clarity and cooperation among international jurisdiction. 3 years later, in 1886, Berne Convention extended the same protection to written expressions. Within half a decade, trademarks were also granted international protection through Madrid Protocol. Resulting offices from the convention later merged into a central body, the United International Bureau for the Protection of Intellectual Property. This then became a United Nations office. Now it is known as World Intellectual Property Organization. Now, let us discuss further the classification of intellectual property. The first category, the most important, is patent. Patent is a form of right granted by government as invention to their successor in title, giving the owner the right to exclude others from making, using, selling, offering to sale and importing the invention for a limited period of time. For example, patent granted for a new medicine which the researcher has invented. The second category includes copyright. Copyright gives us the creator of a original work exclusive right to use it, usually for a limited time. Copyright may apply to a wide range of creative, intellectual or artistic forms. For example, a book writer owns the copyright for the book he or she has written. Author can sell it to publishing company in return of royalty paid to him. The third category is trademark. A trademark is a recognizable sign, design or expression which distinguishes product or services of a particular trader from similar product or services of other traders. For example, the name of social networking site Facebook name is the property of owner Mark Zuckerberg. No other can start another company in the name of same or similar name. The fourth category is plant variety. This is the new one. Plant breeders' right or plant variety rights are the right to commercially use a new variety of a plant. I would like to give a hypothetical example. If I, being a researcher, develop a pink color rice by research, then I can get the plant breeder right to sell the same and earn money out of it. Now, the fifth category is industrial design right. An industrial design right, sometimes called as design right or a design patent, protect the visual design of an object. An industrial design can be of 2 or 3 dimensional pattern used to produce a product, industrial commodity or handicraft. Now, generally speaking, it is what makes a product look appealing, and as such it increases the commercial value of goods. For example, US design patent D48160 for the origin Coca-Cola bottle granted to Coca-Cola company. Now, sixth category is geographical indications. It may be used for a wide variety of products, whether natural, agricultural or manufactured. It is important that the product derives its qualities and reputation from that place. A geographical indication tag is given to an entrepreneur or a group of businessmen of a particular area, state or country to manufacture goods of good quality. The GI tags are issued as per the Geographical Indication of Goods Registration and Protection Act 1999. Some examples of GIs are Parsimon cheese and the Swiss watches. In India, it is Darjeeling tea and the famous Kashmiri saffron. Broadly, the following acts deals with the protection of intellectual property. First is Trademark Act 1999, the Patent Act 1970 as amended in 2005, the Copyright Act 1957, the Design Act 2000, the Geographical Indication Goods Act 1999, the Semiconductor Integrated Circuit Layout Design Act 2000, the Protection of Plant Varieties and Farmers Right Act 2000, it is also given in the table, these the same things, the IT Act 2000. Out of these, we will be discussing patent and copyright law in the next session in detail. Patent also explained Design Act and Plant Varieties Act. IT Act has been discussed in the previous session. So, today we will have a focused session on trademark law. India's obligation under the Trade related intellectual property rights agreement under WTO for protection of trademark include protection to distinguishing mark, recognition of service mark, indefinite periodical renewal of registration, abolition of compulsory licensing of trademark, etc. Now, with the globalization of trade, brand names, trade names, marks, etc. have attained an immense value that require uniform minimum standards of protection and efficient procedure for enforcement as were recognized under TRIPS, that is Trade Related Intellectual Property Rights. In view of the same, extensive reviews and consequential repeal of the old Indian Trade and Merchandise Mark Act 1958 was carried out and the new Trademark Act 99 was enacted. The said Act of 1999 with subsequent amendment conforms to the TRIPS and its accordance with the international system and practices. The Trademark Act recently amended in 2010 as well. Now, what are the question arises, what are the sources of trademark? There are so many sources. The primary is legislation in India, the Trademark Act 1999 and the rules made thereunder. The second is international conventions, TRIPS is one of them. Third is national treaties, fourth is regional treaties, fifth is the decision of the Supreme Court, High Court and the inferior courts, sixth is office practices and other rulings time to time. Seventh is the decision of Intellectual Property Appellate Board, the textbook written by academicians, the Appellate Board's decision is also the sources. Now, factually speaking, what is a trademark in simple words? If we observe, trademark popularly known as brand names in layman's language. It is a visual symbol which may be a word to indicate the source of the goods, a signature, a name, device, label, numerals, combination of colors used, or services or other articles of commerce to distinguish it from the other similar goods or services originated from the another. A trademark provides protection to the owner of the mark by ensuring the exclusive right to use it or to authorize another to use the same in return of payment. Now, after this long definition, student, you must remember the key point, what actually trademark is. In simple words, trademark is a symbol, word or words legally registered or established by use as representing a company's product. Why you register as a trademark? There are so many benefits. For example, the first primary benefit is exclusive right you earn. The owner of registered trademark enjoy exclusive right over the unregistered trademark. The owner can also enjoy the sole ownership of the trademark. It gives the right to sue the unauthorized user of the trademark registered. It also builds trust and goodwill. The established quality of your product and services are known by everyone through the trademark, and which establish trust and goodwill amongst the customer in the market. It also differentiates your products amongst the masses. It makes easy for customers to find your product. It makes your product and foreseen amongst competitors and acts as efficient commercial tool. It gives recognition to the product quality of yours, because customer attach the product's quality with the brand name, and this image is created in the market about the quality of a particular brand, which helps in attracting new customer, as they can differentiate the quality of a product by the logo, brand or name. For example, we often say photocopy as Xerox, but Xerox is a brand. This is the power of brand that is created. This example is worldwide quoted, because Xerox is a company and people are so influenced by the brand Xerox, they synonymously call photocopy as Xerox. Now, the further advantage is brand create assets. Registration of a trademark creates an intangible asset, that is intellectual property for an organization assigned, franchised or commercially contracted. Now, use of a symbol. Once the trademark is registered, you can use the symbol on your logo stating that it is registered trademark and no one can use the same trademark. It gives the protection for years at lower cost. The online trademark registration is done on a very low maintainability cost. Once you register the trademark, you have just to pay the maintenance cost and renewal cost after 10 years of registering the trademark. And if you see, it attracts best quality of human resources. Young minds aspire to join big brands as it acts as a magnet. It carries, it's the power of brand you create through trademark registration. It inspires the positive image of the organization, and thus candidates are attracted towards them easily. These are so many benefits of trademark. Now, we must know what are the various types of trademark prevalent in India. There are around 6 to 7 categories. Number 1 is word mark, then service, logo and symbol, shapes of goods, collective trademark, GI tag mark. Let us discuss with example. I have given the table of all so that you can browse it easily. The word marks are the most common type of trademark that are registered in India. This refers to any mark that are used to identify the product and service of a trading company or a service providing company. If the name of your product or service is text based, because it contain only text, this type of trademark is only in the form of text, it will be registered under word mark. For example, the word Nestle, you just registering the text, the word Nestle, it is registered as a word mark, because you are registering the name of the company. Now, number 2 is service mark. Service marks represent the service which is a company or a business which deals in. It distinguishes different service available in the market and is filed under trademark class 35-45. It is a special category. The most common example is Federal Express, is a registered courier delivery service provider. It is official partner of Amazon also. Third category is logos and symbols. A logo is a printed or painted, figured, design character and do not consist of any letter, word or numerals. For word marks that are also used as a logo, the trademark needs to be registered both as a word mark as well as device mark. In India, the registration for both these aspects can be made in a single application. This is the benefit you get in India only. For example, the Apple Corporation has a registered logo in the form of apple half eaten, which is used on each of their products. The shape of goods, this is very interesting. The shape of a goods are categorized in trade dress, a special category of trademark, wherein other than a logo or a label of product can also be distinguished based on its packaging. For example, the bottle of a Coca-Cola is distinguished from another brand on the basis of its bottle shape. Now, fifth category covers service marks. Service marks are trademarks which have a common syllable, prefix or suffix, thus denoting as a family of marks sharing a common name. They should differ only as to matter of non-distinctive characters like goods, price, quality or size. For example, McDonald's have a series of MC Mac registered as word mark which represent their different product range such as Mac Chicken, Mac Veggies, etc. Sixth category is collective trademark. These marks are linked with a group of people and not one single product or service. These trademarks are primarily owned by an organization, institute or any association. They can be used by members of the organization to represent them as one of the part. They are the badges of origin which indicate the specific source of the individual or their product and services. A very common example is, you have also always noticed the term CA is written on the car of chartered accountants. So, chartered accountant can use the CA device as he is a registered member of the ICA, that is Institute of Chartered Accountants of India. 7th category is certification mark. The certification mark is created to show a specific quality standard that the company has met. This means that the public will be aware that the trader's goods or services are certified as it has met a particular standard as defined by the certifying body that owns the certification mark. Certification marks are used to define standards of goods and services. A very common example is FSSAI certification for the quality of packaged food product. The wafer packet you eat, just observe the pickles you buy, always FSSAI is written on that. I have shown it with the help of a picture also. Now, the 8th category is very special category known as geographical indicators. A geographical indication is used on product to show the unique nature, reputation and quality of the product possessed by on the place of origin. The GI are awarded by a GI registry and is granted to natural, agricultural, manufactured and a handicraft product that comes from a specific geographic origin. For example, our favorite morning drink, the Darjeeling tea, is a GI under the intellectual property right, because it fixes its originality and you are not given an inferior product rather than non-Darjeeling tea which you do not want to. Now, the question arises, what is an unregistered trademark? Now, let us discuss the same. An unregistered trademark is one which does not possess any legal benefit. Under section 27 of Trademark Act 1990, interestingly, no action for infringement is allowed for unregistered trademark. It can still be protected by means of common law under the Tort Act by the term passing off. Now, what is registered trademark? A registered trademark confers a bundle of exclusive right upon the registered owner, including the right to exclusive use of the mark in relation to the products or services. The Trademark Act 1999 governs the whole process of registration, valid for 10 years. It identifies the origin of goods and services, advertise goods and services, guards the commercial goodwill of a trader and protect the innocent public from buying the second rate quality goods. Now, question arises, who may apply for trademark? Now, any person which can be individual, company or proprietor or a legal entity claiming to be the owner of trademark can apply. The application for trademark can be filed within few days and you can start using the word TM as depicted on the screen as a symbol, and the time required for the trademark registry to complete formalities is 18 to 24 months. You may use the word registered R as shown on the screen, registered symbol next to your trademark once your trademark is registered and registration certificate is issued. Once registered, a trademark is valid for 10 years from the date of filing, which can be renewed time to time. The application for renewal can be filed 6 months before the expiry of the validity period of the trademark. Now, the next interesting thing to talk about is what are legal requirements for registration of the trademark in India. Now, there is a complete procedure. The legal requirement to register a trademark under the legislation are: number 1, the selected mark should be capable of being represented graphically, that is in the proper form. It should be capable of distinguishing the goods or services of one undertaking from those of another. There are so many documents required for trademark in India. First, the trademark or a logo copy, the applicant's detail like name, address and nationality, and FOI of the company and the state of incorporation. Goods or services to be registered. The class 3 digital signature certificate is required. The date of first use of the trademark in India, if used by prior before application, has to be mentioned. The power of attorney to be signed by the applicants as well. The trademark registration procedure is done through a very famous website of Government of India, ipiindia.com. I have shown the URL on the screen, and there is a complete DFD flow how registration is done. The trademark registration in India, there are certain important steps. The first is trademark search. The following tips are useful while selecting a trademark. First, it should be easy to speak, spell and remember. Invented words or coined words are advisable. Avoid selection of a geographical name. Avoid adopting laudatory words or words that describe the quality of goods such as the best, perfect, super. It should be avoided. It is advisable to conduct a survey to ascertain if same or similar mark is used in the market. Perception studies can be conducted by the management students. Now, next thing which is important for discussion is filing trademark application in India. After you are sure that your chosen brand name or logo is not listed in the Trademark Registry India, you can opt for registering the same. The first step is to file the trademark application form at the Trademark Office India. Further, you can see the trademark status of your application immediately online. 3 completed copies of forms are submitted along with the 10 additional representations of the trademark. In addition to details of the applicant, the application must also indicate the class of goods, services to which you would apply. The following information should be mentioned in the form: the class of goods for which the mark is sought and should be specified. Classes can be textiles, food, confectionery, machine, tools and so much as you want to, and you are dealing in rather, and separate applications are required for applying in different classes. The definition of goods that is sought to be registered should be given. Details of the applicants including name, age, occupation, address and nationality should be given. Whether a trademark is in use or is proposed to be used, it is in use, then applicant must specify by whom it is being used and for what period. Who can use symbol R in India? Only the proprietor of the trademark whose trademark has been registered in India can use word R as indicated on the screen in India using the symbol, unless your mark has been registered in India. Otherwise, it is lawful to use this kind of mark shown in the symbol on the screen. Now, question arises, when can the symbol using this symbol, when can the symbol TM is used in India? Now, TM is also depicted on the screen, its format. Using this symbol with your trademark simply implies that your claim to be proprietor of the trademark is under the process. There is no prohibition on the use of symbol TM in India. Now, after this, a very common question people often ask, what are the rights of the holder of a registered trademark? It is given under section 28, rights confirmed by registration. The first is exclusive right to use the trademark in relation to the goods or any services and to obtain relief in respect of infringement. Now, where there exist 2 or more trademarks which are identical with or nearly resembles each other, the exclusive right to use those trademarks shall not be deemed or have been acquired by anyone. The common case you should refer to is Clinic versus Gufic Limited. It is a very common case. I recommend students to go through this case law. Now, a common question is trademark infringement. It is given under section 29 of the Act. Infringement of the registered trademarks, it deals with a registered trademark is infringed by a person who, not being a registered proprietor or a person using by way of permitted use in the course of a trade a mark which is identical with the trade in relation to goods or services in respect to which trademark is registered. A very famous case is between Tata Sons versus Greenpeace International. Second case is Coca-Cola versus Bisleri, and third case is Yahoo versus Akash Arora. I advise students to all to go through these case laws, which gives you detailed examples of rights and their infringement. Now, there is interesting things to note that section 27 says no action for infringement of unregistered trademark. No person shall be entitled to institute any proceeding to recover damages or to prevent the infringement of an unregistered trademark. Nothing in this act shall be deemed to affect rights of action against any person for passing of goods or services as the goods of another person or as services provided by another person or the remedies in respect thereof. The case related to this is Cycle Corporation of India versus TI Ralag Industries Private Limited. Now, what does not amount to trademark infringement? Section 30 deals with it. It limits on effect of registered trademark. It says that nothing shall prevent the use of registered trademark provided the use in the accordance with honest practices. It is not infringement where the use indicates the kind, quality, quantity, intended purpose, value, geographical origin, the time of production of goods or of rendering of services. The third category include where the goods bearing a registered trademark are lawfully acquired, the sale of the goods in the market or otherwise dealing in those goods is not infringement of a trademark. Now, what issues arise in a suit for infringement of a trademark? In other words, if the owner of the trademark alleged to be infringed, does trademark subsist in the scenario alleged to have been infringed? This is the issue which arises. The second is, does what the defendant has done or purpose to do constitute infringement of the trademark? Does the defendant do come within the scope of any of the exemptions to the infringement? And what remedies the plaintiff is entitled to? These questions you must sort for answers. You must seek the answers of these questions. Now, the things are, what are the remedies for the infringement of the trademark in India? There are two types of remedies available to the owner of a trademark. First is an action for infringement in case of a registered trademark. This is a statutory remedy, and second is action of passing off in the case of unregistered trademark, and this is a common law remedy. It is not in trademark law, it is given under tort law. And the well known trademark and transborder reputation concept is there. India recognizes the concept of a well known trademark and the principle of transborder reputation. There is a very famous example also that we will be discussing. Now, a well known trademark in relation to any goods or services means a mark that has become so to the substantial segment of the public which uses such goods or receives such services in a way that use of such mark in relation to other goods and services is likely to be taken as indicating a connection between the two marks. Transborder reputation concept was recognized and discussed by Apex Indian Court in the landmark case of N.R. Dongre versus Whirlpool in the year 1996. The trademark Whirlpool was held to have acquired reputation and goodwill in India. The mark Whirlpool was also held to have become associated in the minds of public with Whirlpool Corporation on account of circulation of the advertisement in the magazine despite no evidence of actual sale. Hence, the trademark Whirlpool was held to have acquired transborder reputation which enjoys protection in India, irrespective of its actual user or registration in India. Now, there is a term passing off. Now, let us see the legal remedies against it. Under Trademark Act, both civil criminal remedies are simultaneously available against passing off. And as we know, passing off is a common law tort used to enforce unregistered trademark rights. Passing off essentially occurs where the reputation in the trademark of party A is misappropriated by the party B, such that party B misrepresents as being the owner of the trademark or having some affiliation nexus with party A, thereby damaging the goodwill of party A. Now, let us see the infringement penalty further. Trademark infringement is a violation of the exclusive right attached to a trademark without the authorization of the trademark owner or any licensees, provided that such authorization was within the scope of the license. Infringement may occur when one party, the infringer, uses a trademark which is identical or confusingly similar to a trademark owner by another party. Offences shall be punishable with imprisonment for a term of minimum 6 months, but which may extend to 3 years, and with a minimum fine of ₹50,000, but which may extend to ₹2 lakh. For adequate and special reasons mentioned in the judgment, the court may impose a sentence of imprisonment for a term of less than 6 months or a fine of less than ₹50,000. Trademark infringement example case, a very famous case which we are going to discuss is Adidas versus Forever 21. As we all know, Adidas is a famous shoe brand and Forever has multiple products through its stores. Adidas was very recently filed a lawsuit against clothing retailer Forever 21, alleging that the retailer's product, which contains 3 strips design, constitute counterfeit product to build and protect of 3 strip design as a trademark component of their brand and own numerous patents. While representatives for Adidas and Forever 21 have not released further comments in regards to the lawsuit, since initial statement, it remains to be seen how the court will respond to the lawsuit. Given the similarity of Forever 21 store and the Adidas product and distribution channel, Forever 21 may have been able to avoid this lawsuit by evaluating their recent design against Adidas product and trademarks. Let us conclude today's topic. My dear students, in today's session on intellectual property law and trademark, we saw concepts, registration procedure and infringement cases along with live cases. This module is taught in information security context of MOOCs entitled Information Security and Cyber Forensics. As maximum trademark violation is easily done in online environment in terms of cut, copy, paste, you should be able to identify trademark violation in cyber world. I wish you all a very happy learning. Thank you so much.